Jai Swaminarayan. Okay. Good afternoon, and it's nice to be with you guys today. It's honor and pleasure. Is it better? Can you hear me? Okay. So, first of all, I would like to thank the entire Swaminarayan temple management for organizing this event. And we can explore different aspects of the new Trump policy as well as the executive orders, which has just come in almost every day. In addition to almost 78 executive orders have been rescinded. They've been canceled. So it will have some impact on a different group of people in a different way and manners. So I would like to take a small voting before I proceed with my presentation. How many of you are here on an F1 visa or OPT, STEM OPT, CPT? Okay, that's a big number. And how many of you are here on a working visa, HLO, MNOP? Okay, so we have both group of people represented in our mass. So should I start related to F1? Seems like F1 I'm going to start first. And from F1, we're going to move into, OPT, STEM OPT, CPT, and then dive into the H1B, Cap-Gap H1B, H1B, transfer extension, amendment, as well as L1, L1A, L1B, and any other visas, including O1, EB1A, NIW. And you guys can ask questions. We have the system set up in how to ask a question, or you can just raise your hand and ask a question. We'll be more than happy to entertain. So having said that, let me talk to you about the burning issues of the current news, right? So birthright citizenship has ended through the executive order. And that executive order has been stopped by the court in Seattle, in Washington. The judge issued a TRO, they call temporary restraining order. That means the executive order which was announced by the White House on January 28th cannot be implemented at this point of time, quote unquote. So it has a 14 days debarment. Right now, it cannot be implemented. So after 14 days, there might be other lawsuits in California and other states which are leaning Democrats. They will be suing the Trump administration in that particular topic of birthright citizenship issue. So for now, after February 19th, if there is no other changes in the slowdown of that executive order, then people who have, like you guys, who are on F1, let's say you have a child after February 19th, then you need to file maybe F2 for this kid to remain legal in the country, even though the kid was born here. So if this law is not stopped on time, you need to keep that in mind. H1B people might have to file H4. L1 people might have to file L2 for the same kid who will be born after February 19th. So that is the real impact of the birthright citizenship for now, for our community. In general, people used to come to the United States on any visa, whether legal or illegal. Either they came through Canada, walk-in, they call EWI, entered without inspection, or through Mexico, or you came on a B1, B2 visa, or any other, let's say R1 visa, or H1B visa, F1 visa, any way, shape, or form, if you had a kid, that kid was automatic U.S. citizen under the 14th Amendment. So the 14th Amendment says anybody who was born here in the United States is a U.S. citizen. Anybody who was born in the U.S. or jurisdiction thereof. That's the definition. So now the Trump administration has trying to define what is the jurisdiction thereof. So they are saying the jurisdiction thereof means the person who is in the United States as a US citizen or green card holder, or one of the parent is a US citizen or a green card holder, and they have a baby, that kid is going to be subject to the jurisdiction thereof, of the US jurisdiction. So we don't know how this thing is going to be interpreted by different courts, but eventually it will reach to the US Supreme Court. I'm anticipating in about 1 year or a year and a half. This case should be in the Supreme Court. And Supreme Court is quite a bit tilted towards Republican side. So the time will tell how this interpretation is going to be justified. The 14th Amendment is going to be justified by the court or the judges at the Supreme Court. The time will tell. But for now, you want to be mentally ready. If there are no other options available, then people who are on non-immigrant visas, you want to keep your kid legal. In order to do that, you might want to explore the F2, H4, L2, or some other visas, whatever primary visa and the dependent visas are there. So that much should suffice, right? So each time the US government changes, the presidency changes, there are consequences of that particular political belief or the party. I've been practicing this immigration law since Bill Clinton. So Bill Clinton time, he passed the law before he left. They call INA 245I. Under the INA 245I, anybody who was in the United States on or about December 19 of 2000 was eligible to apply under the 245I, either the family-based or employment-based green card, even though they were EWI or visa overstay or they were illegals. So since then, there is nothing of that scheme has come to the United States, legal system yet. So now how these things are going to move is Biden is gone. Now Trump administration is here. Their focus is on the immigration. Immigration. That's how he believes that's how he was elected. So for next 6 to 9 months, the focus is going to remain in immigration. That means the visas on the different pretexts, right? It could be national. Right now, they have national emergency in the southern border. So nobody can come, or people who are going to get there and try to apply for the citizenship, asylum are going to be turned back. They will not be able to do it anymore. So, remain in Mexico policy is going to be implemented as well. So the southern border is going to be technically closed. Now, not a lot of people or your relatives are going to be walking from southern border, so it's not a big deal for you. So now let's talk about what is a big deal for you. It will be the visa situation where normally people travel to the United States on B1, B2, H1B, H4, L1, L2, or P3 for culturally unique programs, or R1 for the religious worker. So those are the normal visas we will be dealing with today. So those visas are going to be also very, very restrictive. So the interpretation, visa issuance at the consulate or embassy is going to slow down, most probably. And the standard for issuing visas are going to be raised astronomically. So that would be the scenario on getting F1 visas or B1, B2 or H1, H4. So if anybody is in the United States right now, you should not be leaving the country and trying to get a visa stamp in India for next 6 to 9 months. You should just stay here. That would be my advice. So now I was wondering, should I also speak in Hindi in between? So you guys won't mind. My Gujarati is not that great. I can understand pretty well, but speaking time, એટલા માટે I need to speak in Hindi. બરાબર? ચાલ. So that part of the Gujarati came out well, seems like, right? Okay. So I mean, we're gonna use both the languages in between, right? So that's the scenario. So we need to kind of making sure you're not stuck. अब वहां जाके वीजा अप्लाई करोगे और वीजा नहीं मिला और 221G मिला कि तुमको ये डॉक्यूमेंट दिखाओ वो डॉक्यूमेंट दिखाओ, particularly IT consulting companies, right? Those are going to be no, big no. And even you were working for the end client directly. On H1B or L1, there is no, vendor or tier in between clients. You should not go because still there could be a 221G or the processing delay on a national security ground. They want to make sure there are some embassies or the consulates where the local documentation are so garbage. इतना बकवास document मिलता है उधर कि American government doesn't trust it. That means they were not going to issue visas there. No F1, no B1, B2, H1, anything like maybe Pakistan or some other country where there is very loose system in place where US government or the embassy or the consulate or the Department of State doesn't have a trust or verification against it, okay? So now, that's the one area where I see there is one enhanced vetting and screening, right? That's what I was talking to you about. They have an executive order on that also. So under that executive order, the visas are going to be scrutinized, whether there are non-immigrant visas or immigrant visas, family-based immigrant visas, employment-based immigrant visas, as well as जो HL, MNOP, जितने भी non-immigrant visas हैं, F1 visas, all of them are going to have negative consequences of adjudicating or processing at the U.S. embassies. Now, it's not only U.S. embassies. You have port of entry. Let's say you got the visa, you came into the port of entry, so they might question if you are on a third-party placement, right, client side, or maybe you had paid H1B filing fee. They might ask you, okay, who paid the filing fee? Who manages? Who is the actual employer for that H1B visa? Who controls the employment while you are working at the end client site? So all of these different issues you need to keep in mind when you travel. Prepare yourself. Read the I-129 petition letter, either where you are on H or L visas. LCA, salary, job jurisdiction, how you report to your H1B employer. How do you communicate with them on a weekly, bi-weekly, or monthly basis? So all of these issues are very critical for your successful re-entry into the United States, because if you go around there and make a mistake, you won't be, they're not going to let you come in. You'll be going back home. You'll be in Ahmedabad. Barabar? So we don't want to be in Ahmedabad right now. There is nothing wrong with Ahmedabad, but your goal or your destiny right now is New York or New Jersey. So Ahmedabad is going to be maybe बाद में जाएंगे घूमने के लिए, अभी नहीं. So in this context, I pretty much covered what is really important to you in executive orders, right? The national security ground, health ground. The government is going to bring a lot of immigration, executive orders, regulations, and eventually, maybe in 6 to 9 months, there will be a new immigration law. Because right now, the House, the Senate, the White House is all belong to the Republican Party. So this is the only time they can pass laws, actual laws. There will be a change in immigration. What I am hearing from the different sources in the government is they might eliminate the labor certification process, where the employer files the labor. and then go into a point-based system similar to Australia and Canada. I mean, we don't know how it actually is going to, pan out down the road, but that's what the news is right now. If you are in the area of these employment-based cases, employment-based visas, try to ask your employer or try to file a labor certification as soon as possible. So if they do not eliminate the process retroactively, at least you have already submitted the labor certification, which will give you the green card eventually, whether it's a EB1, EB2, EB3, right? Employment-based, there are 3 green cards. So either one of the firm, whether you're going to file EB1A, you don't need an employer. NIW, you don't need an employer. Labor certification-based EB2, you need an employer. EB3 is only going through the labor certification, you need an employer. So whichever firm you can afford to apply, whatever is your qualification, right? Try to use this time until they change the law to file either EB2, EB3, or EB1 or NIW-based green card application as early as possible. So that would be my recommendation for you guys. अहमदाबाद से ट्रेन जा रही है बॉम्बे, अब आपने वहां अंदर नहीं घुसा, ये एप्लीकेशन नहीं डाला, ट्रेन छूट जाएगी और you're going to be in the station at Ahmedabad. Okay? So, having said that, I am going to, the other things, what, I saw so many Q&A, right? The question and answer these guys have sent. I think the other topics we're going to cover there. So this much is enough, right? For the executive orders and the current immigration situation, you guys already know. You might be watching news and then checking what's going on every day. I'm doing that for my living. You guys are doing even more for your own benefit, right? So you guys know as much as I do. So we're on the same page. Koi wanda nahi. Barabar? Okay, let's move on to the Q&A. So how is it going so far? Is it helpful, the information? Okay. Okay. Oh, बीच में, I'm going to start to speak more Hindi. English हो गई. Okay. There's too much English. Okay.
One item, if we can all scan, if we could go back to the QR code. I want to give everyone 2 minutes. Scan this, read as many of the questions as you can in the next 2 minutes, and upvote or give a thumbs up to the ones that you think are most pertinent to you. And we'll get those answers from Keshav.
The funny thing, let me tell you one thing. The funny thing was, I did so many of these Masana and Kalul people green card long time ago, and my name was converted in Keshubai. Keshubai. There was a chief minister before in Gujarat, so under his name I became Keshubai. Yeah.
Beautiful. Usually we give nicknames to brothers.
I know.
And if you allow us to call you your brother,
yeah.
Keshubai is good.
Keshubai. I know. Thank you.
Good.
Yeah.
Okay. As you guys are reading and asking questions and writing the questions and upvoting, is everyone done or you need more time? 1 minute. Continue. We'll ask questions. Keshubai, number 1 question right now. I am currently working in an NGO unpaid on my OPT. Can I go back to India and come back? Can I apply for H-1B from NGO provided that this work is unpaid? I'm currently working in an NGO unpaid on my OPT. Can I go back to India and come back here? Can I apply for H-1B from the NGO? It's unpaid work.
Thank you. So, a lot of people have the same issue, right? H-1B में क्या होता है कि When you file H-1B, most of the people are going from F-1 to H-1B. Whether you're OPT, STEM OPT, or CPT. That's the life cycle of the, OPT F-1 visa to the H-1B. So the OPT law requires you to be employed by for-profit or non-profit. It really doesn't matter. It could be any type of institution or the company can employ you so long as the employment is minimum of 20 hours. So 20 hours employment is there. You should not be going to India if your OPT, see, OPT is 1 year. So if your OPT is expiring, you're leaving on 10th or 11th month, you should not be going to India. So if you want to go to India, you should go to India you should not cross maybe 8-9 months. If your OPT, first year OPT, is within 9 months, then you can go to India for 2 weeks and come back. Provided you have this job, you are working in the particular scenario here, it's a non-profit organization and it's an unpaid job. There are two things to remember, right? Which is legal, there is no problem. But you gotta prove it down the road. Because a lot of these non-profit, they haven't given you need to have some kind of evidence how you are engaged with them. Do you go to work every day? Are you working remotely? Or you report once a week? And what do you do? What is your work product? So that issue might come even when you file a H-1B, change of status. That same nonprofit can file, and the USCIS can question you and ask, how did you maintain your status? Maintenance of status, right? How did you maintain it? And you say, well, I worked for this nonprofit 20 hours unpaid. Okay, I agree. What did you do? Nothing. There is no work product. And when you ask this nonprofit guy, can you give me a letter verifying I did so-and-so work? Now he's afraid. He doesn't give you the letter. You see? You could become out of status. So it's easy to say, then don't, because all of this drama I'm talking to you right now, I have done live from my office. Because that's the experience I'm sharing with you. For all of these cases I'm talking right now, non-profit, no money, yes money, little money, everything I have done in 30 years. So be careful. It is okay. Everything is legal when you have unpaid, but prove it. Have documentation, number one. Number two, if you are working remotely, how are you reporting to this company? What proofs is there? Are you doing some work and sending by email? Or they have a dashboard or a portal where you report your daily work or weekly work? Some kind of a mechanism you need to have in place so you can justify if there is a question by the authority in the veracity of this employment. Okay? The second question is whether you can go on H-1B. So there are two types of H-1B, right? One is a Cap-Exempt H-1B, another is a Cap-Subject H-1B. Cap-Exempt H-1B, you could apply from this nonprofit so long as the nonprofit is associated with a research institution or some university system in one form or the other. They need to have some sort of a memorandum of understanding of conducting research or providing certain data or certain work. So if you have that kind of a nexus between these two entities, then you don't have to be subject to H-1B lottery. You can be Cap-Exempt. If you don't have that, then you're going to file a Cap-Subject H-1B. You're going to apply in March in the lottery. If you get selected, then you have April, May, June, 3 months to apply, unless Mr. Trump changes something down the road. Okay?
This was a popular question. Was this, whoever asked these, there was about 20 upvotes. Do you need any clarifications on this? Was this clear? Okay. My own question. How many clients have you served in the past 30 years?
You know, it's a very interesting question, right? We have done more than 100,000 people's work. Yeah. So, yeah. Jai Swaminarayan.
100,000 and about 400 it'll be soon.
I know.
Can we go from H1B to EB1?
Of course, of course. So the EB1, see, you have bunch of EB1, right? You have EB1A, EB1C. The EB1C is filed by the L1 people who come on L1. EB1A, on the other hand, is filed by people by themselves. It's a self-petition. अपने आप apply करने का. So you don't need an employer. It's like the labor certification is not needed. You're just going to apply, proving to the U.S. government or the USCIS you are a person of extraordinary ability. Well, how are you going to prove that, right? So there are mechanisms proving that. So normally what happens is everybody thinks he's extraordinary or she is extraordinary in their home. Okay? But they might not be extraordinary or exceptional ability alien in the eyes of the US government or the USCIS. So the EB1A is the fastest green card among all the categories, EB1, EB2, EB3, EB4, EB5. All employment-based green card categories, among all employment-based green card categories, this is the fastest one. तो ये fastest क्यों है कि there are very few people can qualify for this. Number one, I think India is running right now around 2022. That's the best. So if you look at the EB2 priority date and the EB3, I'm talking about, 12, 14 years. So 14 years में तो राम भी आ गया था लंका से, you see. So it's a long wait on the other categories. Now EB1A, how do you qualify for EB1A for a person who is on H1B? That means there are different types of people, right, on H1B. Maybe you are in the field of science, technology, engineering, math, healthcare, data analytics. Everybody is doing business analytics in MBA now. So it could be a data scientist. So any profession could qualify so long as you can prove 3-4 things, right? A lot of people, once you get into the H1B, you're already working there. We need to look at what is your job title there, under what role you're playing into that company. Or before you come into the US, maybe you worked in India. So that might be also can be looked upon, right? So first thing you want to see is what is your original contribution to this company or the places you have worked. How you have been able to make a very high profit for this company, and then how you're able to save the cost. So every business has two prongs. One, making money, making more money. Second is reducing the cost in making that more money. So in these two angles, how you have been able to provide or put your original contribution to that efforts. So you want to look into that, right? And then how you have played a leading and critical role into that success of that company. So you have 2 points, right? Original contribution, leading and critical role. And then the rest of the things are going to be displayed through your money, salary. Is your remuneration or the salary is highly paid? You're making like $325,000 for this particular job. You are a project manager. But you're dealing with a project which has really, big value to the company. It's making billions of dollars. So depending on the nature and the scope of the project, salary, original contribution, leading and critical role, awards and recognition, as well as publications into the field of your, whatever area you have been successful. And then that publication is, you wrote a book, you published 4 articles in that particular field. Is this articles or books is cited by somebody else? Some other researcher or the other professionals in that field, they are taking high value information you have provided through the articles or the books, have it been cited? So all of these things I'm summarizing, right? They have 10 categories of different membership, awards, recognition, original contribution, all of these areas I just talked. You need to meet 3 out of 10. Then you have an EB1A green card. I-140 is going to get approved in about 6 to 8 months. I don't recommend you to file premium processing on I-140 in this EB1A category because they issue, the premium department has older guy like me. So they are tough. So you don't want to go there. So don't do premium because you're not getting any benefit. Your priority date is already created on the day you submit the application. And now, if you just stay there because the priority date is not current, even they approved in 2 weeks, to green card the file ho nahi sakti. You're going to wait for 2 years because right now 2022 is current. I'm talking to you in 2025. So no point in spending $2,800 for making premium and then you might get denied. So EB1A is possible from H1B as well as NIW is possible. NIW is also very similar, but it has 7 categories. You need to meet 3 out of 7. The guy who doesn't qualify for EB1A, he needs to go into NIW. That's what the math is. If you have ability to meet this higher threshold, you go EB1A. The case is weaker for the EB1A, then we bring it down to NIW. Or multiple times I have filed both the cases. You see, EB1A and NIW. And one of them will get approved. If they deny EB1A, NIW is going to get approved. But the criteria is pretty much similar. NIW has a lower criteria, obviously, but they call national in scope and intrinsic merit. So you have, let's see, you are a data scientist. The work you're doing for a big bank, let's say Citibank. Data scientist, where you can figure it out. The work you have done, let's say you are implementing artificial intelligence or business intelligence, right? So that AI or the business intelligence application is going to stop a guy from Russia or China to mug in this bank. That is a national in scope, international in scope. So it depends how we present the case, but there is a synergy there. There is a possibility of qualifying under this and interpreting that as a intrinsic merit in national in scope, and you are a person of exceptional ability. You have risen to the top of the field by the salary, recommendation letters, as well as your progressive experience in that particular field. That's what's called NIW. So you ask me EB1A, and I also answer about NIW. Does it make it clear? Koi chakkar wala kaam hai? You understand, right?
If you have questions, raise it. Okay, we're going to keep going here, but on this specific one, go ahead, stand up and
Shoot.
make a question. Louder.
Yeah?
And there's a higher class of the and you mix there the older people. So how do you know that all people only handling those cases, not like the system should be the same, right? But how do you know that the only older people is dealing with the premium processing and the younger people is dealing with the non-premium processing?
See, the thing is, what happens here is it's a cost-benefit analysis, right? The premium department charges $2,805 for the fee. So for that money, they need to respond within 2 weeks, right? 2 working weeks. That means 3 weeks. You have Saturday, Sunday, too. So in order to respond in that fast environment, you need experienced officers. The new rookie guy who just became an immigration officer, he needs like maybe 1 day to read that I-140 petition and the support letter. But guy like me, I can read your petition in less than 1 hour because I know exactly where to read, where to find the mistakes, or where the weakness is there, or where the strength is there. So because of that, the premium department has these experienced officers. Because of the movement of the time, right? The time has to move so fast, the rookie guy cannot deliver the same product. And now what happens is, if you file a premium directly, 95% of the time, they're going to open your file maybe 1 day before the deadline. Okay? He doesn't have time to read. So they have a template of RFE prepared by their lawyer in DC. They send them. And he look at it, okay, he changed the name, put 15, 20 questions there, prove. You don't meet this, you don't meet this, you don't meet anything. And maybe he hasn't even read very thoroughly. And he will send that RFE. Now, what we do is, when we submit these cases, we give them maybe 70% of the material in the first filing, anticipating RFE. When RFE comes in, if I don't have anything, they will deny that case. But if I have 30% of the material with me, I can repackage the same thing, right? And then make a faluda out of it and give it to him. Here we go. Sir, please drink. And wo piyega. Usko maza aayega. You see. So that's how it works.
So
I have a second question.
can we, we'll just hold it till the very end, as there are many other questions as well. So let's hold it to the end.
Sure. Thank you.
Couple questions. We have a lot of questions here. We'll have to shoot quick on a lot of these, okay?
I'm gonna shoot more.
No problem, but there's many. What is the process from F1 to EB1, slightly different, after completing PhD, and how feasible is it?
Okay. I mean, a lot of people, right? If you are on F1 and completed PhD, a lot of students are going to be in that position, right? To complete the PhD, you have, I mean, again, it depends, right? Depends on whether you have a STEM degree or non-STEM degree. Most of the STEM degree is going to have 2 more additional years of STEM OPT. If you have a management degree or some, non-STEM degree, then you have only 1 year. So you can file the I-140 regardless of whatever, STEM or not non-STEM. The only issue is going to be whether you can remain in the U.S. or you might have to go on a day 1 CPT with another, or, another PhD or MBA. And then also file EB1A green card. He can file or she can file, but if you have planned to go back to India, then you should not file. Because if you have to return back on F1 visa again, and you already filed the I-140 petition on an EB1A, and which is pending or which is already approved, but you have not filed the 485. In that situation, the officer at the embassy might not give you visa, number 1, because you have displayed your immigrant intent by filing the I-140 on EB1A. Or even at the port of entry, if the CBP officer sees it in the computer, he has filed I-140, or he already has I-140 approval, and he might refuse the entry. Not all the time it happens, but that you need to keep it in mind when you try to change the status.
I think you explained the NIW criteria,
Right.
but it's coming again. If you can briefly explain the eligibility criteria to apply for NIW.
Sure. So I just said before, right? You have 7 criterias. Out of 7 criterias, you need to meet 3 for NIW. So let me just, advanced degree or exceptional ability, national interest, well-positioned intrinsic merit, I already told you. And then it is national in scope, and it will benefit the entire United States. So those are 4 prongs you need to meet. How are you going to meet, right? you're going to meet, as I said before, you're going to prove you are an expert in that field. You are a person of exceptional ability. You have a degree, maybe you have a master's degree, or you have a bachelor's degree, and you have 5 years experience, which becomes an advanced degree. Either master's or BS plus 5, which becomes an EB2 in labor certification, as well as for NIW purposes. Now, you may have only bachelor's degree and 10 years experience, or progressive experience in that field. How are you going to show your progressive experience, right? Through the places you worked in the past, you're going to collect the recommendation letters. And then you're going to also show your income. So you started with, let's see, $50,000, it became $100,000, $200,000, $300,000, you became a super guy. So all of these indices of your progression needs to be presented to the Homeland Security. So you could have awards, you could have, again, publications, you could have patent. If you are an engineer, or a mechanical engineer, or software engineer, data science, whatever area you are in, a pharmaceutical, you can have a patent. So medical device manufacturing, there's so many areas, right? And also you have business management. That also qualifies for EB1A or the NIW. So all areas, but the requirements are pretty much similar. Higher level people who have risen to the top of the field, they're going to be EB1A. Lesser people, that's why they call extraordinary ability. And then they call another English word they use, exceptional ability. Little lower. He's not extraordinary, but he's exceptional. Ye chalega. Okay? So this is how you differentiate. Hope it helps.
Very good. Okay. We'll keep going with questions.
Yeah, please.
Okay? If I had issues previously, example, past employer flagged for shady business, or a brief out of status period resolved within grace period, I'm now in status. Is it risky to travel for visa stamping?
You know what? If I were you, I would not travel right now. Okay? Bottom line is there. Even I'm normal, right? In our question, the guy had a shady company before. He had a shady company associated with him.
And brief out of status period as well, which was resolved.
Which is resolved. So even if that's not the situation, I would not travel for next 9 months. Just to see the storm is subsided, things are a little calm, and then I want to make my journey ahead. But in this particular situation, he is exposed everywhere. CBP can pull him out. If he's applying for visa at the U.S. Embassy, they can see. See, now the immigration is using AI, like ChatGPT type of software. So they can pull it out, your entire DS-160, first DS-160, to the H-1B or L-1 visa you are in the U.S. The entire ecosystem of your visa life, your janam patri padhega wo, pura. You see, किस ग्रह कहाँ है, इसने क्या 7.5 कब लगी थी इसको, वो सब चक्कर हिसाब किताब करके दबा देगा तुमको. हाँ, तो उसके वो चक्कर में don't travel right now. That's my recommendation. Okay.
Good. What are the new rules or changes in OPT and H-1B which we should definitely keep in mind?
You know what? I mean, OPT right now is normal, right? You have OPT 1 year. Under that OPT, you really don't need much fiasco there, as long as you have an employer who is giving you 20 hours of work. If you are working remotely, keep record. Always keep record, because I have seen so many RFEs coming down the road when you file a H-1B. Okay, prove you are maintaining your status. And particularly when the company is in New Jersey, I mean, you are in New Jersey and company is in California. And there were like a lot of these, shady companies were there a few years ago where they were just taking money and giving the letters of employment. And same guy is giving to 500 people employment letter. 20 hours, he's working very hard, but he never came in there. You see. So all of those guys got in trouble. I had these situations in H-1B RFEs. So keep that in mind. Always make sure everything is documented. And then if it's a STEM OPT, it has to be a genuine 983 plan, training plan. So you need to report performance evaluation, reporting to your DSO, as well as keeping record of your work activities. Because the company, they're not going to do anything to the company. It is your obligation to maintain your status and prove you had maintained the status in the past. If you fail to do so, at a particular junction, maybe in a green card time, you are in the final stage of I-485 adjudication, and you don't have the documents to back up. At a certain point of time, you maintain your status. Then there will be a problem. Okay? Thank you.
If anyone got laid off and has a 140 approved, what are the possible ways he can stay if he doesn't get a timely job?
Well, let's assume the person is on H-1B, right? He also has I-140 approved. I-140 approved means that I-140 cannot be canceled by the company which filed the I-140 for 6 months. So make sure the guy doesn't revoke your I-140 for 6 months. After they revoke, after 6 months, after 180 days, even if they revoke, you can use that I-140 to file a H-1B extension beyond 6 years, number one. Number two, you can use the priority date of that I-140 to file another labor certification green card from another employer and retain that priority date because you're born in India, priority date is mother and father right now. You need to retain that, you see. So these two things. Now, the second question is, we talked about I-140. Now, what are the options you get laid off on H-1B or L-1? H-1B, L-1, both the visas get 60 days grace period. Within 60 days, what else you can do? You can try to find an employer. It can be even part-time job. L1 cannot do that. L1 can only work for that company. He is not transferable to other employers. L1 guy might be eligible for O1A because he's a multinational executive or manager. So he can explore to go into O1A visa. Okay? The H1B guy can go into H1B transfer. Let's see, all of these options are kaput. It's not working. Now, they can change into F1 visa, another status, within that 60 days. Or let's see, F1 needed too much money. You had already spent all the money. There is no money. Now, last bet is B2 visa, tourist visa. You can file a change of status to B2. And then continue to look for job, and they approve. Right now, most probably this protocol might change under the Trump administration, but the Biden administration had given B2 as an option for HL or any other non-immigrant working visa folks to go and park their status for the time being while they are searching for the new employment. That protocol is still in effect. और ये बदल सकती है, most probably it will change. So don't try to go on to B2. Okay?
Can I work over 40 hours per week on an H-1B visa? Is there a maximum limit? Can I work 2 full-time jobs, 40 hours each, if the second employer files a concurrent H-1B petition?
Thank you. This has a lot of, there's a lot of money involved there, right? So you're not happy. You're not happy with the $80,000 salary. You want to make 160. I understand that. That's why we're here. So the law firm I used to work after my graduation, we used to work more than 85 hours a week. You see, every week. So it is normal in America to work 80, 90 hours a week. But we work 7 days a week, 15, 16 hours a day. So that's how we made a living. So it can be done. So because of this American protocol, as you said, as long as it's a concurrent employment, and then you're working 40 hours here and 40 hours in another company, now you can even work remotely, right? Remotely, maybe for both the employers. So all things are possible as long as you're in compliance with the H-1B and the LCA law. The only question is going to come is one job is in New York, another job is in California, and then there is no remote protocol there, which is explained, and they might make you illegal for unauthorized work. So keep that in mind to incorporate that job site location. As long as you do that, I don't see any problem. To work reasonably 2 jobs. You should not have 3 jobs on H-1B. Then there are no enough hours now. That becomes a fraud. You really did not work, you see. More than 80 hours, I would not do it.
0 hours of sleep.
No.
If you have 0 hours of sleep. No.
Of course.
What is automatic revalidation while on H-1B? How to exercise it? How many times can automatic revalidation be used over a lifetime?
I mean, see, the question is, the revalidation means whatever visa you had on the passport, that is, same visa is being granted to you. The new visa, you cannot revalidate. You need to get the new visa at the consulate, right? So I used to have in my office 2 people just for the revalidation until 2005 or 6. So all of these H and L visas were revalidated at the State Department office in DC. So we sent all of these passports, completed DS, OF 156 used to be there, and then it became DS 160. All these applications we used to send there. So that's the revalidation, right? You could do as many times as you want. But now, Biden gone, I don't think revalidation is going to continue. I don't know how you're going to even get the visa at the consulate or the embassy, forget revalidating in DC without leaving the country. So that option is going to be 99% eliminated by the Trump administration.
Next question is on the Trump administration. Is it possible that employment-based green cards processing become faster, especially for India, while there is tech companies' support in place?
What company you say?
In Trump administration, is it possible that employment-based green cards processing become faster, especially for India, while there is a tech company's support in place?
Oh, okay. Thank you. Well, I mean, nothing is going to be fast right now, let me tell you. If you look back the history, when the Trump 101 administration came in 2017, things were pretty drastically cut because a lot of immigration officers, visa officers were sent out to the border, in southern border, in Mexico. So because of that, the adjudicating portion of the USCIS business really halted. It was very slow down. So I anticipate employment-based, family-based, all across the board, things will be slow moving forward. Just it's a different priority and the policy of the new administration. It should not be moving fast. So first, your priority dates are not going to move past number 1. And number 2, even if you file the 485, the benefit of the filing the 485 is you already have ability to get work permit and the travel permit, and which will help you to remain in the U.S. or change the employer without having headache of getting the green card. But it will not move fast.
What is the process for students to start their own business and for them to apply for their visas?
Well, it's a good news right now, right? If you look at the new regulations, which came on January 17th, so the Biden administration brought a lot of things on January 17th because they were leaving on January 20th. It was the 3 days regulations. So all of these Biden regulations, which allows the H-1B person to open a company or become a stakeholder in an existing company, owner on the company, have ownership in the company, and then apply for H-1B visa. All of these rules, there is a more than 99% chance it's going to go away. If it doesn't go away, you could do it, you see. But the chances is, don't do it right now. Wait until the Trump administration's policy, how they're going to treat this Biden policy, which they haven't announced yet, but eventually within a week, couple of weeks, or a month or 2 months, before the H-1B filing takes place, it's going to come.
Keshu we're still going to have you for 10, 15 more minutes, okay?
Oh, sure.
And
Keep shooting me.
there's 44 questions, so we're not going to get through all of them. But
Don't worry.
it's good that everyone continue to upvote because
Right.
this is the last couple of questions. So please go in, continue to upvote anything that's pertinent to you. Can I switch to a B1, B2 visa after being laid off and later return to H-1B? Is it advisable or could a status gap cause issue? Can I extend my B1, B2 visa if it expires while in the US?
B1, B2?
Can I switch to a B1, B2 visa after being laid off and later return to H-1B? Is it advisable or do you think a status gap can cause issues? And is this due to current situation or will it become, one second, sorry. Can I extend my B1, B2 visa if it expires while in the US? Okay, couple questions there.
Yeah. B1, B2, you're not going to extend anything here. B1, B2, their visa and their status, these are two different things, right? B1, B2 visa is given by the consulate in your passport. B1, B2 stamp. So that is the B1, B2 visa. B1, B2 status, on the other hand, is given by the USCIS because you're on H-1B, you got laid off, you're trying to find an employer, it's been 1.5 months, no employer is entertaining, you want to remain legal in the country, so obviously you're going to file under the current Biden administration protocol, you're going to file a change of status to B2 to park yourself on a valid legal status. That is all good. So when that B2 is approved, you're going to get I-94 as a B2. That is not a visa. That is a status. You're on a B2 legal status with the I-94 called B2. So from B2, you can move into back to H-1B within the validity of that B2 status. So what we do right now is, let's see, we file a B2 and B2 is pending, right? You found a job. B2 takes maybe 3, 4, 5 months for them to approve, but after filing the case, after 1 month, you found a job. Now you have a B2 pending. Now you don't have to do right now a premium conversion to that visa. You can file H-1B as a change of status from B2 to H-1B on premium processing and attach the B2 receipt notice and explain to the Homeland Security, look, I have a B2, this employee has a B2 pending, approve the B2 first, make the I-94, then approve the underlying H-1B, and they will do it. So that's how we've been getting approvals. It is doable. Hope it helps. Okay.
I am currently a PhD student. What are the opportunities regarding O1 visa?
Right.
What criteria should I be meeting?
Right. Okay. So O1 is a non-immigrant visa. EB1A is an immigrant visa. So the EB1A or exceptional ability, extraordinary ability or exceptional ability qualifying background person who has again patent, awards, membership, recognition, progressive experience, original contribution in the field, leading a critical role, and quality publication cited by a lot of other people. That person can be eligible to apply for O1A visa, okay? There are O1A and O1B, and there is a O2, you see, and there is a O3. So O1A visa is given again to the STEM people, mostly, or management, sciences, arts. Everybody would qualify so long as you prove those prongs, right? Similar to EB1A and the EB2, exceptional ability. So O1B is a, artist primarily, television artist. We have done maybe in 2024 about 10 cases for cook on O1B, Indian cook, but they are famous cook. So they will make dal bhadi, which you have never eaten anyway, special dal bhadi. Like this, they are specialized cook, they are eligible for O1B visa, and they come from India also. So O3 and O2 is the assistant, right? The person who is assisting this O1 guy. It could be in movie. So we bring assistant cook under O2. So there will be O3 is the dependent. It's like H4, L2. O3 is for the dependent family members. So those are the story of the O1. PSD to O1, it is 100% possible, but we need to evaluate the background. Whether you have all those metrics you have met, then you have a possibility.
Two very similar questions. What is your opinion on Trump's statement on giving green cards to college graduates? Would that apply to current OPT, STEM, and OPT? You also have the option not to answer this question, okay? And the second question is, Trump mentioned in an interview that everyone who has a master's or is highly skilled in the US would be given GC or citizenship in one of his statements. How serious was he? And I just want to preface and disclaim, we're not making any predictions. We are not saying what's happening in the government. He will give his best educated guess on this because we cannot predict what's happening after 1 week of him being in office. So you could answer as such.
Thank you. And you know what? If that happens, Jai Swaminarayan. Okay? So the chances are very low. Let me tell you the truth. So while Mr. President was speaking for a different election campaign, different areas, which makes sense, right? If you have got an American master's degree or PhD, you should staple a green card with that degree and then give it to you, so you don't have to worry about this OPT, STEM OPT, 60-day rule, find employment, unemployment, 150 days rule. All the drama can be played in Bombay, not here. So that would be the ideal situation, right? And Mr. Trump could do it. He could do it. But the ecosystem where the Mr. Trump comes from, the Republican Party, is not very favorable. Or the people who work for him, like Mr. Miller, Stephen Miller, who is the assistant chief of staff for the White House. So these folks are not for this kind of benefit, okay, staple the green card. If you can survive on F1, OPT, STEM OPT, H1B, EB1, EB2, EB3 green card, that would be a good thing to hear. So this is far-fetched, but anything can happen, but do not anticipate in the near future.
Two more questions, that's it. Is it possible to legally work multiple jobs on F1 OPT? Also, can I work for an employer on W-2 and another employer on 1099 on F1 STEM OPT?
Okay. So F1 STEM OPT, you could do multiple jobs. Again, you got to make common sense, right? You should not be working more than 80 hours. It doesn't say, the law says the minimum threshold for the maintenance of F1 status while you are on OPT or STEM OPT is minimum 20 hours work. STEM OPT requires a payment because it has to be a market salary for that particular job, which is related to your degree or major field of study. Number one, you want to pay attention to that. And then the OPT can be, or the STEM OPT could be more than 20 hours. And as we discussed before on the H-1B context, up to 80 hours, it might be doable because then you don't have to commit any fraud. 80 hours you could work. So OPT, you could just work because you have an OPT card. They can fill out the I-9, attach the passport copy and the OPT card, you're done. But the STEM OPT requires a salary and a 983 training plan by each employer. You could have multiple employers, but the multiple employer must provide the training plan to the DSO or whatever you call at the university who manages the 983. So long as you have all of these documented and you're working in multiple jobs with the multiple companies, I do not see there is a break in status. You can maintain the status.
Last one. If my spouse's green card is approved and I hold an independent H-1B status, not dependent, do I automatically get a green card or is a separate process required?
Well, it depends, right? When you got married, number one. Number two, did the wife was a primary applicant for that I-485, did she file a dependent 485 for you? If she filed a dependent 485 and your 485 is pending, your wife got the green card, but your 485 was filed in a different time because you got married after 2 years of her filing the 485, then you're going to have to wait until the priority date becomes current again, and then you will get the green card. Now, you didn't file a green card, right? You didn't file a dependent I-485, but you remain on H-1B. Your wife got the green card. Now she needs to apply I-130 petition as a green card holder to the spouse, you see. That's how you're going to move forward.
We have a trick question here. I absolutely love this session. And if I reach out
Thank
to
you.
If I reach out to you for services, is there a discount code that I could refer to?
Of course. There will be a discount. A special discount. And just say Swaminarayan. That's the passcode. Okay?
Okay. So, first of all, thank you so much.
Thank you.
This was
Thank
incredible.
you. Honor and pleasure. Thank you.
This was absolutely incredible. We are definitely indebted to you. This was a lot of information that you've shared
Right.
from 30 years of experience and thousands of clients that you've dealt with.
Yeah.
This is not information that we have readily available to
Thank you.
us. So we can't thank you enough. One more big round of applause.
Thank you.
And Keshav bhai, before you go, I would like to call on Nilesh bhai.